Okay. Designation of a facility for the questioning of children in custody, juvenile delinquency. A. The district administrative judge in each judicial district outside New York City and the administrative judge for the family court within New York City or designee shall arrange for the inspection of any facility within the judicial district proposed for designation as suitable for the questioning of children pursuant to 305.2 FCA, and if found suitable, the judge, as appropriate, shall recommend its designation to the fucking chief administrator. Every recommendation shall include 1. The room number or identification, type of facility in which room is located, the address and the hours of access. 2. The name of the police or other law enforcement agency, department of probation, family court judge, or other interested person or agency which proposed the designation of the particular facility. 3. A signed and dated copy of the report of inspection made at the direction of whatever judge as applicable. And 4. The factors upon which the recommendation is based. C. Any facility recommended for designation as suitable shall be separate from areas accessible to the general public and adult detainees. D. Insofar as possible, the judge, in making a recommendation for designation, shall seek to assure that an adequate number and reasonable geographic distribution of designated questioning facilities, and that 1. The room is located in a police facility or governmental facility, not regularly or exclusively used for the education or care of children. 2. The room presents an office-like rather than a jail-like setting. 3. The room is clean and well-maintained. 4. The room is well-lit and heated. 5. There are separate toilet facilities for children, or in the alternative, procedures for ensuring the privacy and safety of the children when in use. 6. There's a separate entrance for the children, or in the alternative, there are procedures which minimize public exposure and adult detainees. 7. A person will be in attendance with the child whenever the room is in use as a questioning facility. Such person to be a police woman or other qualified female person when the child is a female. And 8. Any other factors relevant to suitability for designation are considered. E. The appropriate district administrative judge or the administrative judge for the family court within New York City or designee, when notified of any material physical change in a facility designated for the questioning of children, shall arrange for the reinspection of the facility concerning its continued suitability for designation. F. A current list of facilities designated for the questioning of children within each judicial district and within New York City shall be maintained by the district administrative judge and the administrative judge of the family court in New York City, and shall be kept for easy public inspection in each family court in that judicial district and within New York City. A current statewide list is maintained in the office of the chief administrator. These lists shall be kept available for public inspection. 205.21. Authorization to detention agency for release of a child taken into custody prior to a petition being filed, juvenile delinquency. A. When a child is brought to a detention facility prior to the filing of a petition pursuant to 305.2 of FCA, the agency responsible for operating the detention facility is authorized to release the child before a petition is filed when the events that occasion taking the child into custody do not appear to involve allegations that the child committed a delinquent act. B. If the events occasioning the taking into custody do appear to involve allegations that the child committed a delinquent act, the agency is nevertheless authorized to release the child where practicable and issue appearance tickets in accordance with 307.1 of the Family Court Act, unless special circumstances exist which require detention of the child, including whether 1. there is substantial probability child will not appear or be produced at the appropriate probation service at a specified time and place. 2, there is a serious risk that before the petition is filed, the child may commit an act which, if committed by an adult, would constitute a crime. 3, the alleged conduct by the child involved the use or threatened use of violence. Or 4, there is reason to believe that a proceeding to determine whether the child is a juvenile delinquent or juvenile offender is currently pending. C, any child released pursuant to this rule shall be released to the custody of his parents or other legally responsible person if they're unavailable to a person whom he or she resides. 205.22. Preliminary probation conferences and procedures. Juvenile delinquency. The probation service shall conduct preliminary conferences with any person seeking to have a JD petition filed, the potential respondent, and any other interested persons, including the complainant, on the same day that such persons appear at the probation service, concerning the advisability that a JD petition be filed, and in order to gather information needed for a determination of the suitability of the case for adjustment. The probation service shall permit any participant represented by a lawyer to be accompanied by the lawyer at the conference. B, during the conferences, probation service shall ascertain a brief statement of the underlying events, and if known to that person, a brief statement of factors that would be assistance to the court in determining whether the potential respondent should be detained or released in the event that a petition is filed. In order to determine whether the case is suitable for the adjustment process, the probation service shall consider the following circumstances among others. Here's a list. Age of respondent, and every time I say respondent here, I mean potential respondent. Conduct allegedly involved, whether the acts threaten cause death, substantial pain, or SPI to another person, knowing use or possession of a dangerous instrument, a deadly weapon, the use or threatened use of violence to compel a person to engage in sexual intercourse, deviant sexual intercourse or sexual contact, the use or threatened use of violence to obtain property, the use or threatened use of deadly physical force with the intent to restrain the liberty of another, the intentional starting of a fire causing an explosion which resulted in damage to a building, a serious risk to the welfare and safety of the community, an act which seriously endangered the safety of the respondent or another person, whether there's a substantial likelihood he won't appear at the conferences or with an agency where he's referred to, substantial likelihood he won't cooperate in the adjustment process, whether there's a substantial likelihood that in order to adjust the case successfully, the respondent would require services that could not be administered effectively in less than 4 months, whether there's a substantial likelihood the respondent will commit an act would constitute a crime, engage in conduct that endangers the physical, emotional health of the potential respondent or a member of their family or household, or harass or menace the complainant or a member of that person's family or household where demonstrated by prior conduct or threats, where there's another JD petition already pending or a PIN petition pending, whether there have been prior adjustments or ACDs, whether there's been a prior adjudication of a JD or JO, where there is a substantial likelihood the adjustment process would not be successful unless the kid was removed from his or her home, and that removal could not be accomplished without invoking the court process, and whether a proceeding has or will be instituted against another person acting jointly with the respondent. At the first appearance at a conference, each of the persons listed in sub A shall inform such person that the function of the adjustment process, and there's limitations and alternatives too, and that he has the right to participate. Probation service is not authorized to and cannot compel any person to appear at any conference, produce any papers, or visit any place. The person seeking to have the petition filed is entitled to have access to the appropriate presentment agency at any time for the purpose of requesting that a petition be filed. The adjustment process may continue for a period of 2 months and may be extended for an additional 2 months upon written application to the court and approval thereof. Statements made to the probation service are confidential. If the adjustment process is commenced but is not successfully concluded, the persons participating may be notified orally or in writing of that fact, and the case will be referred to the appropriate presentment agency. Oral notification will be confirmed in writing. If the adjustment process is not commenced, the record of the probation service shall contain a statement of the grounds, and they shall give written notice to the persons listed in sub A who have appeared that the adjustment process will not be commenced. The case will be referred, and they are entitled to have access to the presentment agency for requesting a petition be filed. Concluded. So just remember there's a 48-hour rule in here talking about if they refuse to cooperate and it's not successfully concluded, the probation service shall notify all the persons that participated that it was not successfully concluded, and that the presentment agency will be notified within 48 hours or the next court day, whichever occurs later. They shall notify the respondent in writing of the reasons, therefore, the case was non-adjusted.